Hi, my name is Paul Goyette, and I'm here to talk to you today about what to do if you're involved in a critical incident. So the first thing to figure out is, what is a critical incident? What am I referring to? What am I talking about? Well, a critical incident can affect any number of employees, whether you be a peace officer, a correctional officer, even in the fire service, or any public safety employee, or any non-public safety employee, maybe. A critical incident is when, in the course of your job, you have to use serious and deadly force to accomplish your job, to fulfill the duties of your job. Most commonly, that's an officer-involved shooting, or it's a significant use of force with your hands or other tools or weapons that causes serious bodily injury to a suspect. It could also be the use of your automobile. You run somebody over. You have to use your automobile as a weapon or as a shield. That could be a critical incident. So if you're involved in any one of those things, then there's a number of serious consequences that could happen, and there's a number of investigations that start almost immediately following the end of that critical incident. There's a lot of things you need to know. If you've been involved in a critical incident, the first thing to figure out is what type of investigation or investigations are going on. Well, there's typically going to be two and sometimes three. First, there's going to be a criminal investigation against you, where you're the suspect for the use of your weapon or the use of your vehicle as to whether you've used that unlawfully. For example, if the suspect involved is dead, they're going to investigate a homicide, whether you use your weapon, your vehicle to commit a homicide. So the first investigation is a criminal investigation where you, the employee, are the suspect. The second most common investigation would be your department's internal affairs investigation. And that will investigate whether you violated any department rules, regulations, or policies. Finally, there might be a third investigation to get started. And that investigation would deal with the suspect involved in the underlying case. Did he commit an assault on a police officer? Was he involved in some other crimes? He probably was. That led to you taking the action that you had to take. So there'll be probably three investigations you need to be aware of. Now, each of those investigations will be conducted by separate investigators, or, let me put it this way, should be conducted by separate investigators. So once you've figured out the types of investigations that are going on and who the investigators are, here's the big question. The biggest question you'll face through the course of this process is, should you and when should you give a statement, and what should that statement look like? Well, there's some easy rules to follow. First of all, in the context of this big picture you're in here, get a representative. You do not, under any circumstances, want to be making these decisions by yourself, in a vacuum, in your own head. Get a lawyer, get your representative there to help you. Okay, first, the criminal investigation. Identify who the criminal investigators are, and this is something typically your lawyer would do, is communicate with them. Most of the time, I will never have my clients talk to the criminal investigators the day or the night of the shooting. There are some times where we will talk to the criminal investigators in due time. Once we've interviewed the witnesses, we know what's going on in the case, when we can make an advantageous and informed decision to the criminal investigators on your behalf. The next investigation is the internal affairs investigation. Now, depending on your agency, that internal affairs investigation may start 5 minutes after the critical incident, or it may start the next day or the following week, perhaps. Eventually, you will be required to give a statement to the internal affairs investigation, to this internal affairs investigators. That's not a problem. You're going to do it with your representative. There's a critical thing at play here. You do not give a statement to the internal affairs investigators without being ordered to do so. It's important that you understand an ordered statement under California and federal law can only be used against you for internal affairs or departmental purposes. You cannot be prosecuted criminally for what you say in your ordered statement related to the underlying charge. That's very important for you to know. Finally, you might get asked to write a report or give a statement to the investigation of the suspect who committed the underlying crimes. You can do that. You can do that with an order to do so, typically. You're required to write a report. If you have to give a verbal statement, do it with an order. You'd also want to do that with the help of your lawyer. The last thing I'd say on it, whatever statements you give, they have to be consistent. My preference is that you give one statement and one statement alone. That keeps it simple, that keeps it clean, that keeps it safe for you. If you need other help on this, or if we can answer any other questions to you, you have a lot of options. You can look at our website, GoyetteAssociates.com. You can go on our YouTube channel, Goyette Associates, and we're going to post this on Facebook. Also get in touch with us. Our law firm does a lot of different things. We have a lot of great lawyers and labor specialists that are ready to help you on all kinds of things. Not only your labor and employment needs, but we have great personal injury lawyers. We have great estate planning lawyers. We have great litigation lawyers. If there's anything we can help you on, we want to hear from you. Please. Thank you very much, and I'll talk to you soon.